All right, so let's move on to other forms of clouds on title. A real common one, and I think an interesting one in any state, is recorded judgments. I think this is a particularly interesting topic here in our state of Arizona because we've had pretty substantial changes, recent changes to Arizona's homestead law. So let's talk about recorded judgments, the liens that they create, the clouds that they create, the process of removing them, and maybe the process of when they don't need to be removed given the homestead exemption laws. What does that look like?
So if a judgment is given just for money damages and it does not create any type of lien or constructive trust or otherwise against real estate, it does not specifically list, the judgment attaching to real estate within the judgment, and it's just a money damage judgment, you didn't pay a credit card or there's a lender or something out there that, you ended up being sued for an unsecured debt and a judgment's entered against you. That lender then can record that judgment in any county where you own property, or they think that you may at some point, or you may own property, but maybe they can't find it. They can't identify it. They can record that judgment. And that judgment, at least here in Arizona, acts as a lien on any non-exempt. So that's an important term, non-exempt real estate that the judgment debtor holds within that county. They don't need to identify a specific property. It acts as a blanket lien against any real estate within the county that's not exempt, that's held by the judgment debtor. Now, in Arizona, and most states have them, we have homestead laws, homestead exemption laws. And in Arizona, you're allowed one homestead. So one piece of real estate that you reside in, and that's held in your name or in a like a revocable living trust, like you've put it into a trust for estate planning purposes. So it's in your name or in the name of a trust. Holding in an LLC doesn't qualify. It has to be in an individual's name or a revocable trust for which the individual is the grantor and trustee and beneficiary, et cetera. You have one homestead, and it is now up to $400,000. Andy, you know this. It was at $150,000 forever. I mean,
for as long as I was a lawyer, it felt
yeah,
like
me
that
too.
was just always the rule.
Yeah, that was it. I mean, and it never changed.
No, nobody ever really questioned it.
No. And then about 2 years ago, it goes up to 250,000. Well, that wasn't good enough. And our voters here in Arizona, like a year later, so it hadn't even been like a year later, they raise it to 400,000. So now it's gone within about a 2-year period from 150,000 to 400,000. So it's a lot. That's a substantial amount of equity that you can have in that property and put in your pocket without having to pay your judgment creditors.
Yeah. And to be clear, you just said it, but it's worth saying it again. We're talking about equity here,
right?
Not talking about the end price of the home. We're talking about equity.
Correct.
That is a lot of money.
Right. So, you have a property worth $800,000 and a $400,000 loan against it. And you get to put all those proceeds in your pocket. You get to put 400,000. So you sell it for 800, you pay off the $400,000 loan, and you put 400,000 in your pocket, free and clear of claims of your judgment creditors. Yeah, that's a lot. Now, however, our legislature giveth and our legislature taketh. So they've increased, but they also made it much more restrictive. So when it was 150, the law provided that the judgment didn't even attach to the homestead property. Like it didn't even attach. It wasn't a lien or anything. It would only be applicable if there were proceeds from a sale that exceeded the 150. So it basically essentially attached to the proceeds, but it didn't attach to the real estate, which means what you could do is you could refinance that property and pull cash out and not have to pay the judgment. So if you had a house that was worth 800,000, you owe 200, but you're like, oh shoot, I have a judgment against me and I want to make sure I'm within that, homestead. You could go and refinance and pull, generally up to 80% of the value of the home out in cash, put it in your pocket, then sell it, get your $150,000 homestead and, pay the creditor nothing.
Yeah, and all the title company had to do along the way is really just confirm that we're talking about homestead property.
Yeah, they just would ask the borrower to sign an affidavit confirming that it was their homestead, and they would close the transaction. And the borrower could pull cash out. Well, of course, now our legislature said, no. It's a lien. It's a lien against the real estate. However, a licensed title company or escrow agent, so licensed with the Department of Financial Institutions here in Arizona, is authorized to record a release of that lien if they sell the property and the amount that's going to be of proceeds is not going to exceed, well, I don't want to get too far in the weeds, but they can automatically record the release of the lien if the amount of the proceeds is less than 80% of the homestead amount. If it's greater than 80%, then they have to send notices to the creditor and wait for them to respond. And assuming they don't respond, then they can record the release of the lien. But the significance is there is now a lien against the property, and there are no cash out refinances. So the minute that judgment is recorded, you're locked in. Whatever those loans against the property were at that time is what exists. You can't later go and refinance and pull cash out because the judgment is now effectively a lien against the homestead, except that licensed title companies can release the lien as long as you're not receiving more than the homestead from the sale of the property.